Hello students, how are you? I hope you all are fine. This topic is very important for all those who are preparing for judiciary exams, and this topic is important in your Civil Procedure Code CPC 1908. So what do you mean by amendment of pleadings? There is also one term called supplemental proceedings. So what is the difference between supplemental proceedings and amended pleadings? So let's start. What is a pleading? First you should know this. What is a pleading? According to CPC, pleading mean plaint and written statement. That's it. Pleading includes plaint filed by the plaintiff, and written statement. Written statement is filed by the defendant. So if the plaint is filed by the plaintiff in the court, in answer to it, the defendant files his written statement. Both are included in the term pleadings. There can be any change once the plaint or the written statement has been filed? Can there be any change or correction of an error? Can advocates ask the court, request the court that we want to change something, we want to correct an error? Yes, there is a provision in CPC. We will do that afterwards. But basically, amendment of pleadings is the correction of any error in the pleadings, that is plaint or written statement, before the court, before the civil court. But basically it is only with the permission of the court, not without the permission of the court. If the court gives the permission to the plaintiff's advocate or even the defendant advocate, then they can change something in the plaint or the written statement. So if the original pleading is replaced by a new pleading, it is called amended pleading. This is the thing. If the original pleading is replaced by a new pleading, the new pleading, that is amended pleading. So this amended pleading contains matters omitted from or not known by the plaintiff or defendant at the time of the earlier proceedings. So amended pleadings is basically a correction of an error or filling an omission. So amended pleading is basically correction of an error or filling an omission in the original pleadings by the plaintiff's advocate or even the defendant's advocate. So amendment also means addition of the matter that might have been pleaded at the time when original pleadings were filed in court. The matter might have been pleaded, but which was not pleaded by the advocates due to some inadvertence or skip of the mind by the advocate. However, it all depends upon the discretion of the judge whether he allows amended pleadings or not. It all depends upon the discretion of the judge. So the word amendment includes not only correction of an error in a plaint or written statement, but addition of new matters also, or even deleting of some portions of the original pleadings, and even substituting something in the original plaint or written statement. All these things are included in the word amendment of the pleadings. This is order 6 rule 17 of civil procedure code, very important. Go through it. Order 6 rule 17 CPC, it says that the court may at any stage of the proceedings allow either party, defendant or plaintiff, to alter or amend his pleadings in such manner and on such terms as may be just, and all such amendments shall be made as may be necessary for the purpose of determining the real question in controversy between the parties. So in order to determine the real question in controversy, the court allows an amendment, because until and unless there is the real question in controversy, the real dispute is not known, how you can decide the case properly according to justice. So court allows it. But one thing to be noted here is that no application for amendment, whether by plaintiff's advocate or by defendant's advocate, shall be allowed after trial has commenced. Once the trial has commenced, when the trial commences, once the court frames the charges. So once the trial commences or starts, then there should be no application for amendment of proceedings, and court will not allow that. But here is also there is an exception. Court, if thinks that in spite of due diligence, the party's advocate could not have raised the matter before the start of the proceedings or before the start of the or beginning of the or commencement of the trial, he can allow that amendment. He can accept that application. But generally, once the trial starts, there should be no amendment. But it all depends upon the discretion of the court. The advocate has to satisfy the court that he was really not knowing about this thing. So order 6 and rule 18 of CPC, this is next rule. That was order 6 rule 17. This is order 6 rule 18. It says that party who seeks amendment in his pleadings does not amend within the time given by the court, or if no time given, then within 14 days. Maximum time is 14 days from the date of the order of the court. That party shall not be permitted to amend after the expiry of that time given to him by the court. So generally the court gives the time to the advocate that you can amend this proceeding, your plaint or this written statement within this time, within 7 days or 6 days. And if he does not do that, the court will not allow that. And the maximum time is 14 days. But even then, there is an exception to that. Even the time has expired, he can again give an affidavit. He can file an affidavit to the court, and he can give his sufficient cause. There should be a sufficient cause or sufficient reason behind his failure to amend the pleadings within the time allotted to him by the court. And if the court is satisfied with his sufficient cause shown, court may extend time further. So all depends upon the discretion of the court. So there is also one word, as I've already told you in the beginning of the lecture, supplemental proceedings. What is supplemental proceedings? So in supplemental proceedings also, some matter is sought to be added, not subtracted. Some matter is added by the advocates in the original pleadings. So in supplemental proceedings, the advocates add some matter in the original pleadings, which is very, very important, very material to the issue. So it should not be left behind. But that matter, that important matter, has actually arisen subsequent to the filing of the original pleadings. This is very important. That matter has arisen after the filing of the original pleadings. So this is the case. So advocate is not at fault here. Basically, that matter has arisen after the filing of the original pleadings. So after getting the permission of the court, he can file the supplemental proceedings. So supplemental proceedings basically is a form of amended pleadings only. As I have already told you earlier, the word amendment includes not only correction of errors, but even addition of new matters. So it was all about the amendment of pleadings and supplemental proceedings. I hope you like this lecture. Thank you very much.